Every law, every policy, every historical event has a story. Welcome to UPSC Lens. Welcome to this video on The Emergency Lawmaker, where we decode the executive ordinance system in India, specifically Article 123 of the Constitution. The core dilemma is whether the Indian government can make laws when Parliament is not meeting. The Constitution mandates that Parliament makes laws, but when an urgent situation arises during a recess, a legal mechanism is needed for instant action. The constitutional solution is Article 123. It grants the President the legislative power to promulgate ordinances when Parliament is in recess. Crucially, an ordinance is a temporary law with the same force as an act of Parliament, but it is not a dictatorial decree, as it's exercised only on the advice of the Council of Ministers. The ordinance formula requires three elements: a Parliament gap when the legislature is not in session, an urgent necessity for immediate action, and executive action which includes cabinet advice and the President's signature. This results in the ordinance, which is a temporary law. The ordinance window shows that an ordinance can only be born during the recess gaps between the budget, monsoon, and winter sessions. If both houses of Parliament are in session, the President's power to issue an ordinance is entirely suspended. The chain of promulgation begins with a crisis during parliamentary recess. The Union Cabinet then recommends action. The President signs the draft, satisfied that immediate action is necessary. Finally, the ordinance is officially promulgated and takes immediate effect. The ordinance's shelf life is governed by the, quotes, 6 months plus 6 weeks rule. It lasts a maximum of 6 months until Parliament reconvenes, and then must be approved by Parliament within exactly 6 weeks of its reassembly, or it automatically lapses. The ordinance power has a dual nature. It has equal force to an act of Parliament but carries inherent fragility, meaning it's designed to be temporary. It also has retrospective reach, allowing it to be backdated, but it cannot amend the Constitution. The complication is the repromulgation loop. This loophole occurs when Parliament is prorogued, an ordinance is promulgated. Parliament reconvenes but the bill isn't introduced, and the ordinance lapses. It is then repromulgated, allowing the executive to bypass Parliament indefinitely. The Supreme Court intervened in the D.C. Wadhwa Case in 1987, where 256 ordinances in Bihar were kept alive for up to 14 years. The court struck this down as a, quote, a fraud on the Constitution, establishing that ordinance making is an exceptional, not alternative, legislative power. Jurisdictionally, Article 123 applies to the Union, with the President as the authority advised by the Union Cabinet. Article 213 applies to the state, with the Governor as the authority advised by the State Council of Ministers. The legislative scope and veto mechanisms differ between the two. The constitutional blueprint is based on checks and balances. The executive provides agility through the ordinance, the legislature holds supremacy by requiring approval, and the judiciary ensures accountability by monitoring misuse. This balanced system ensures the state never halts while preserving democracy. If this video helped you understand the topic better, subscribe to UPSC Lens for more visual explainers.